Good afternoon, everyone. My name is Stuart Pemble, and along with my colleagues Alison Garrett, Dominic Jones, and Iain Murdoch, I would like to welcome you to our latest Foundations webinar on the Building Safety Act. The webinar is being recorded, and you'll be sent a copy of the slides and a link to the recording at the end. If you have any questions, please write them in the Q&A tab in Zoom. So by way of a quick introduction and recap, a huge number of changes came into force in October last year, particularly relating to the building regulations. Many of those changes relate to all buildings. Some of those changes relate to high-risk buildings only. A reminder, a higher risk building has to be 18 meters or 7 stories tall and have 2 or more residential units, unless it is a hospital or care home, where during construction work at the cost hospital or care home, and that includes repair or modification, if it meets the height requirement, the building is a higher risk building. A lot of transitional provisions came into force on the 1st of October last year, and as it says on the slide, those transitional provisions are horribly complicated and too complicated to cover in an hour's webinar. So if you do think the transitional provisions apply, do seek separate advice on it. The other key date to remember is the 6th of April this year, and what we're going to do is talk through 10 of the key changes from October and April. In relation to all buildings, we're going to discuss the requirement for there to be a principal designer and principal contractor for the purposes of the building regulations. We're going to discuss notices to building control authority before starting works and once works are commenced. We're going to discuss non-compliance with the regulations, and we're going to discuss registered building control approvers. In relation to higher risk buildings, we're going to discuss the new building safety regulator and gateways 2 and 3. We're also going to discuss Alison's favourite topic, second staircases, remediation contribution orders, and building liability orders. As ever with the Building Safety Act, there's just been a huge amount of change incredibly quickly, and we thought that these 10 made sense being held together. So first up, building regulations, principal designer and principal contractor. Dom, do you want to talk us through the change?
Yes, you'd be delighted to. So what we're talking about here are the new duty holder roles and the building regulations 2010. So we have the roles of the client, designers, contractors, the principal designer and principal contractor. And whilst those roles share their names with the roles that will be familiar to many under the CDM regulations, which focus on health and safety, these new roles relate to compliance with the building regulations. As you said in the introduction, Stuart, these roles apply to all projects that are viable under the building regulations, not just higher risk buildings, although there are some specific requirements, additional requirements where you have a higher risk building. One of the key requirements on the client is to appoint a principal designer and a principal contractor. So when those appointments need to be made is one of the things that depends on whether you're talking about a high risk building or not. So for a higher risk building, the PD and PC must be appointed before the building control application is submitted to the building safety regulator. And for other buildings, those appointments must be made before the construction phase. But for reasons that will hopefully become apparent when we talk a bit more about what's involved in discharging the roles, in practice, the principal designer will need to be appointed earlier in the design phase.
Thanks so much. And when the employer's considering appointing who to appoint, are there any issues they should be aware of?
There are a number of issues they'll need to be aware of. So it's a very pertinent question, Stuart. And I think the way I'd introduce it is to say that a central theme of this new regime is is behavioural change to bring about a focus on competence, moving away from what was perceived as a box-ticking mentality, which was criticised heavily by Dame Judith Hackett in her review following the Grenfell Tower tragedy. So what this means is that the client must be satisfied that its principal designer and principal contractor each have the necessary competence to perform their roles. And in the case of higher risk buildings, the client must check that the PD and the PCC have not been subject to sanctions for non-compliance. And just thinking about competence, there may be a question in some people's minds around, well, how would a client be expected to know whether the people they are appointing are competent to discharge these roles? And the answer is it's not going to be straightforward, but there is guidance around what is meant by competence. And there was recently published some guidance for project managers around the competence requirements. And that guidance does include some commentary around how a project manager can support clients in ensuring that the PD and the PC have the necessary competence. So that's worth looking out for.
Thanks. So what must the principal designer and principal contractor actually do?
Well, principal designer, as you'd expect in the name, must be a member of the design team. And the PD has responsibility for planning, monitoring, coordinating design work. And that includes assessing the design work to make sure that all of the designers comply with relevant building regulations. Now, that's not to say that the principal designer is expected to be an expert in all design disciplines, but it must be able to assess whether a design will, if built, meet the building regulations. The principal contractor takes over during the construction phase and has responsibility for planning, managing, monitoring and coordinating building work. And that includes assessing building work to ensure that it complies with the building regulations. And as part of that, making sure that building work done by all contractors, i.e. all of those discharging the subcontract packages, that work also complies with the building regulations. And where the principal designer or principal contractor is appointed for higher risk building work, there are additional duties, including the obligation to establish and operate a mandatory occurrence reporting system, storing the golden thread of information, and keeping records of steps taken to ensure that those appointed to do the design work meet the relevant competence requirements.
Thanks so much. So pretty onerous, which raises the obvious question of what happens if either or both aren't appointed?
Well, the obligation is on the client to make sure they are appointed, and if not, those duties fall back to the client. So it is an onerous one.
It is an onerous one. And just in case that hasn't, that's excited everyone on the webinar, where are all these changes to be found?
Well, introduced by one of the many pieces of secondary legislation, but we put on the slide there, it's part 2A of chapter 1 in the building regulations.
Yeah, fantastic. Thanks very much.
So we're moving on now to look at the notices required to be submitted to the Building Control Authority. And previously, we only had one notice to deal with. Alison, now we're talking about two notices. I wondered if you could talk us through the changes there.
Yes, we are. There are two notices that need to be served now, and they differ slightly in terms of their timing, depending on whether you're a higher risk building or not. If you're a high risk building, you need to serve your first notice 5 working days before work starts. And if you're a non-higher risk building, you only have to serve it 2 working days before the work starts. The second notice in both cases has to be served no more than 5 working days after work has commenced, which might lead you to the question, what's the difference between starting work and commencing work? They sound pretty similar to a layperson.
That's right, isn't it? They are terms that don't sound like they're going to be too different, but I think you're going to help us understand what the differences are in this context.
Yes, slightly surprisingly, there is no definition of started work. The government, in a circular letter that it issued originally in October last year and then updated in February, said that it wasn't going to define what started work meant, but went on to say that it expected it to consist of the undertaking of any element of permanent notifiable building work as described in the applicant's application or initial notice. So this is a theme that we see a little bit, that it's putting the onus on the applicant to say when they think works will have started. Broadly speaking, I think in layman's terms, we're probably talking about starting, meaning once you put a spade in the ground, which is probably what we all think about in relation to starting work in any way. Commencement, however, is something very different, and we do have definitions in relation to commencement. They're quite complex, but for new builds, broadly speaking, it's going to be when the foundations have been completed and when the structure of the lowest floor level of the building has also been completed. So that's a world away from putting your spade in the ground, and perhaps started means what we think it means. Commencement means something very different to what we normally mean by commencement. There's also, for any other building work that doesn't fall within either complex building, which is defined, or a non-complex building or a horizontal extension of a building. So broadly speaking, works to an existing building which don't require a horizontal extension. For those works, commencement is going to mean when 15% of the proposed work is completed, which, Dom, is somewhat odd. How do you work out what 15% is? And that sort of leads me back to what I said about what started work means. The onus is going to be on the applicant again. In the application to building control, the duty holders are going to have to say what they think 15% is.
Yeah, no, and it feels as though there could be quite a lot of work done, depending on the scale of the project, between the spade and the ground, which should be quite clear to work out, 15%, if that's what you're looking at. Yeah, as you say, determining when that 15% of work has been carried out may be relatively straightforward on some projects, the standard fit-out scheme. But where the bulk of the work activity happens all at once, so you're installing a modular unit or a piece of structural steel, it's a much more complicated question. And Stuart's moved us on to the next slide, so I will catch up with him. And this is bringing us back to the recurring motif that this is all about delivering meaningful changes in behaviour. So the regime around non-compliance with building regulations sees a step change in terms of the time periods during which enforcement action can be taken and the consequences of non-compliance. But before we look at those, Alison, can you tell us what it is that we mean by non-compliance with building regulations here?
Yes, this is a major change, and non-compliance broadly means where either plans or an application were required and you don't actually deposit plans or get approval, and you just start work, or where you do deposit plans or make an application and that's rejected, but you start work anyway, or where you actually get approval but you do something different to what you'd got approval for. Those are all covered by non-compliance.
Right, so previously, doing those things, an authority could have taken action against you for a period of 12 months after that non-compliance. That period is now 10 years. So it's really demonstrating how much more seriously this is to be taken. And in terms of sanctions, those have really stepped up as well. So until now, sanction for non-compliance was a summary only offence, with a fine of up to £5,000 and then a nominal figure for continued default after conviction. We now have an either way offence, which is punishable by an unlimited fine or imprisonment of up to 2 years or both, plus a level 1 fine, so around £200 a day for default post-conviction. But I think it's clear that this is intended to send a message that non-compliance is going to be taken much more seriously. And we've put on the slide here, which you'll receive afterwards, a link to a blog by another one of the building safety specialist team here, Lauren Lafferty.
Thanks very much, both. Dom, registered building control approvers, which sounds a mouthful. Who or what are they?
Well, you may have heard of them referred to previously as your building control approved inspectors, so private sector inspectors can approve building control purposes. No less of a mouthful now, but the big change is that those businesses discharging the building control function need to be registered with the building safety regulator. And that registration has to have happened by the 6th of April 2024. Although slightly confusingly, the time period for completing training and the competency assessment has been extended until the 6th of July. There is a public register, which is accessible via the web link on the slide here. And that will be very important to check, particularly given the competency assessment continuing. That register records the details of each registered building control approver, the start and end date of their registration validity, any conditions attached to the registration, and importantly, the type of building control work that the approver is registered to do. So an obvious example will be if you're doing work on a higher risk building, you need to make sure that your building control, your registered building control approver is registered to do work of that type, work on buildings.
Thanks. What happens if they aren't registered?
Well, the consequences are quite simple, really. If your registered building control approver is not registered, then they're not an RBCA and they can't do building control work. So simply, an unregistered building control approver cannot take on new building control work after the 6th of April. There are transitional arrangements which apply to those who are not intending to register and will therefore be leaving the profession. So for higher risk buildings, it's very clear the 6th of April date is a drop dead date. For other buildings, the transitional regime says that as long as work is completed by the 1st of October 2024 this year, then you can have a building control approver who is not registered. But if you get to if you're now doing work on a high risk building without a registered building control approver, or if you get to the 1st of October 2024 on other projects, your approver is not registered, you must appoint one who is registered. And as the final bullet point on the slide says, that means you may need to recommence your building regulation approval application and deal with all the timing and programme consequences that could bring.
Thanks very much. It brings us neatly on to the regulator themselves. So Iain, who is the regulator?
Thanks, Stuart. The regulator is the building safety regulator, and it's a neat point just to remind everyone, as Stuart indicated at the top of the show, at the top of the billing, we're at roughly the halfway through point, and we've moved from the all buildings world to the higher risk buildings world. So one way to think about the building safety regulator is if you're working in connection with building regulations control of a higher risk building, then your regulator is the BSR, the building safety regulator. And the regulator at the moment is part of the Health and Safety Executive, a team operating within the Health and Safety Executive.
Thanks. And what's their role regarding gateways? We're going to come on to discuss gateways in more detail, but what's their role?
So we haven't mentioned Gateway 1. That's not an omission. Gateway 1 is the planning application stage. But then Gateways 2 and 3 is where the BSR is formally involved. And those terms of art, Gateway 2, Gateway 3, were used a lot when the changes to building regulations were being discussed, and are still used as we talk about it every day and as others in the industry talk about it every day. But those phrases don't specifically appear in the legislation. So if you are reading the legislation, don't look for Gateway 2 and Gateway 3. So Gateway 2 is the building safety regulator approving the building control application. Instead of your local authority, instead of your old school improved inspector, you have to go to the building safety regulator, who will either give approval or not of your building control application. That's Gateway 2. Gateway 2 allows you then to move into the construction phase, and at the end of the construction phase, if you satisfy the regulator that you've complied with all of the obligations that they expect, at the end of that construction phase, they will grant you a completion certificate. And when the BSR grants you the completion certificate, that is passing through Gateway 3. Both of those gateways are in the world of building regulations and building control. They're just new specific gateways relating to the higher risk building regime.
Thanks so much. And what other duties does the regulator have?
Well, as we've alluded to, and as Dom mentioned, I think on the previous slide, that they keep registers. And for those of you who are property developers, as well as contractors and professional designers, and therefore are looking not only at the construction aspects that we're focusing on today, but also considering the Building Safety Act's regulations for the occupation phase. The Building Safety Regulator is the regulator for that occupation phase as well. They keep the register of higher risk buildings. They keep the register of the accountable persons, principal accountable persons for those buildings. And overall, they are the regulator for the higher risk building regime. That means that if you're not sure who your regulator is, but you're working with a higher risk building, the chances are you're going to be talking to the BSR. But then, and very briefly, because we're focusing now on higher risk buildings, there's also the wider control of the building safety regime after the changes introduced by the Building Safety Act. So the BSR is also the body that assesses, that monitors all building control bodies overall, irrespective of whether those building control bodies are working with higher risk or non-higher risk buildings. And it keeps the register that Dom mentioned of registered building inspectors and registered building control approvers. It's the statutory authority, if you like, that is in charge of keeping those registers.
Thanks so much. Which now brings us on to Gateway 2. Could you tell us a bit more about that, please, Iain?
Yeah. So Gateway 2 is required for the higher risk buildings before work commences. So before you can start work on your higher risk building, you need this Gateway 2 approval. You need to have your building control application approval made. The time frame to that grant of approval is important. If you are working on a new high risk building, the regulator has 12 weeks to consider your application. And if you are working on an existing high risk building, the regulator has 8 weeks to consider your application. But I think one of the key takeaways we would share in our experience on higher risk buildings to date is that the quantity and perhaps quality of information required to get through Gateway 2 is more than you might have expected from previous building safety regime, in line with the step change that Dom has been talking about. So you're not going to be able to just pull everything together one day and submit it the next. So the period of time that you need to get through Gateway 2 is going to be more than 12 weeks or more than 8 weeks, because it's going to take some serious work to gather together all of the information you require to make that application.
Thanks so much. And what happens if either people start on site and approval's delayed, or if approval's never given at all?
Well, I think this is something that we're going to have to work out as an industry. Often when we're working on a building, and here we're talking about high-risk buildings, but there's a certain pressure in the system to get the thing built, get it occupied, turn it into a valuable asset rather than just a construction site. And therefore, we're going to want to, for example, on the face of it, grant possession of a site to a contractor who's been working with us, let them set up their site operations, put the hoardings up around the site, for example, finish any ground investigations or anything like that. There's all sorts of reasons why we might want them to take possession of the site before works commence. But if we've given possession and then we have trouble getting regulatory approval, what will happen? If we imagine a JCT design and build contract, and I'm talking about the 2016 form rather than 2024, I don't think the 24 form has changed much in this regard, but we haven't had a chance yet to review it. Attend our next webinar if you'd like to learn more. There in the JCT DB16, you have the ability to defer possession, but that deferral of possession might need to be extended if you're talking to the regulator. And also there's the risk of giving possession, but then something significant happened. I know it's unlikely, but the regulator looks at the plans and says, I'm sorry, you just have to go back to the drawing board. I am not satisfied. Well, in that scenario, you've signed the building contract, you've given possession, but you can't start work and there's no immediate prospect of when that's going to be. You need to address the consequences of that in your building contract. Otherwise, you just may end up in a situation where everyone is forced into a dispute because you haven't agreed in advance where the risk should fall of those sorts of events occurring.
Thanks. So potentially complicated and difficult. Let me give you a different conundrum. You have got approval, work started on site, but the client wants to change the design. What happens then?
Well, here we've got again a new specific and statutory regime for high risk buildings. The obligations on those involved in design and construction include having a formal change control process in place. That's irrespective of whether there's any major change or notifiable change, which I'm about to come on to. But if you are in that scenario, Stuart, and it's a significant change, it's adding an extra floor onto a building, change of use from an area that was going to be residential to now be office or vice versa. That's likely to be, we think, and you'll need to discuss this in each individual case with your professional team, a major change. If you're making a major change to a scheme, you've got to stop. Take that to the regulator, get the regulator's approval. They've got 6 weeks to determine that application. You can't carry out works if you're making a major change. So an example might be you start digging foundations and find that the ground conditions, you've been incredibly unlucky where you've dug your trial pits. Ground conditions are fundamentally different to that you'd expected. It's going to take a redesign of your foundations. You can't just plow on regardless. You've got to stop, submit that major change to the regulator and get it all approved. If you're making a less significant change, and I suppose an example, but again, please check with your professional team on site, where a material that's been specified or a product that's been specified has been replaced by a new product, and I'm thinking in particular of anything that's structural or related to fire safety, although that may well be much broader. You might have a notifiable change where you can continue at risk on site. You don't have to stop work, but you must notify the regulator of what you're doing, of the change that's been made, and tell them. Again, in practice, we think that quite often you're going to want the regulator to agree whether they need to make an extra inspection, whether there is any risk that something might need to be opened up. But there is the ability to carry on performing the works if you're making a notifiable change. But fundamentally, there's got to be a change control mechanism. If you're making major or notifiable changes, involve the regulator.
And yeah, I suppose this might be a slightly obvious question, but it's ultimately it's going to be the regulator who decides whether a change is a major change or a notifiable change, isn't it?
I think so, and therefore I think we've got to start off on the basis of being cautious, being conservative until we have more guidance, until we have professional teams who are used to dealing with these situations in practice will then be able to advise us in much more detail about exactly what the regulator does or doesn't require of us. But yes, I think we need to allow the BSR to lead on that, at least in the short term.
Thanks, Ian. Stuart, so we now move on to Gateway 3, which is the completion certificate for high-risk buildings. And that's, as Ian said previously, a completion certificate relating to the building control process, not the contractual completion, practical completion certificate or practical completion statement. Important to keep those distinct in your mind. And again, there is a statutory time frame for the building safety regulator to review an application for a completion certificate to be issued, and that's an 8-week period here. And I think there's an understanding that the capacity of the building safety regulator is likely to be stretched at times. So good practice is going to be to try and ensure that the BSR is as well informed about your project as possible by providing regular updates and information through the works phase, and making sure the required inspections take place so that when that application is put in, there is nothing new in it. And important to say that the consequence of not having your completion certificate is that your higher risk building cannot be occupied. So it's a fundamental step towards putting your building into use. So Ian, we've got this building control completion certificate. You have your contractual practical completion regime. How do we see those two working alongside each other?
I think, again, it's similar to the answer I gave before, Dom. Just our advice has got to be try and make sure that you have addressed this in your building contract. Leaving it to chance is potentially going to lead to dispute. But I think as a fundamental, if we imagine, again, a typical project, and we're advising on all sorts of projects at the moment, but a typical project where it's a property developer working on a scheme. Clearly, there's got to be a residential element in that scheme, and there are third-party funders involved. Everyone is interested in completing the works such that the completed works can generate an income stream or can be sold to repay the third-party finance that's come in to allow everyone to make the profit and move on to the next job. And everyone has probably agreed that there is a single point of responsibility, or at least the passing of the majority of design and construction risk across to the design and build contractor who's being paid to manage the whole package of works. In that scenario, is the building truly practically complete under the building contract if it can't be occupied? So we suggest that while every project, every higher risk building project is likely to be unique in some respects, often the pressure is going to be on the contractor, and the amendments to the building contract are going to suggest that to achieve practical completion, the completion certificate must be achieved. Otherwise, there is, if you like, an asset that isn't going to be able to generate value because it, as you said, cannot be occupied and cannot be used. And obviously, that's the easiest to answer in relation to a new build HRB. And we would suggest as a starter for 10 that the completion certificate is part of the test for practical completion. That means that you need to consider what the impact of that longer period is, what additional prelims will be paid, maintaining site security for that additional period, ensuring that insurance can be maintained for that additional period, and that everyone knows what they've signed up to from the start, because during that period, while we're waiting for regulatory approval, you can't be performing the works as well. The works must be complete in order to apply for the completion certificate. So there is a new period of time there and a new process for everyone to navigate.
Yeah, absolutely. And if as part of that that process, the duty to prepare and submit the application is delegated to the contractor in its capacity as principal contractor, which the regulations allow the client to do. I'm assuming that doesn't mean that the client can wash its hands and say, I've required the principal contractor to submit this application, so I'm off scot-free. Is that right?
I agree, Dom. There's no way out for clients in this process. Even if you, as a client, are delegating the day-to-day applications, the liaison with building control, and you've gone through and you've ensured that your building contract is back-to-back with that intention, you still need to be involved in those applications for the completion certificate, for the Gateway 2 application as well. As a client, you still need to sign off to the best of your knowledge. The building regulations have been complied with. The client is intimately wrapped up in the process of building regulations, approval and consent, particularly for higher risk buildings, but indeed to a slightly lesser extent for all buildings now. You can't just delegate and walk away. You're intimately involved. And I suppose the next question on the screen about already occupied buildings is a good example of that. You know, you're going to have, as client, obligations in connection with, for example, liaising with the people who are already in occupation. You're going to be managing your strategy for engagement with the residents, and there are all sorts of aspects there that you probably don't want to try and wash your hands of to a contractor. You're going to need that occupation phase obligation to carry on hand in hand with the works that the contractor is trying to deliver for you.
Thanks both. Sorry, Dom, have I cut you off? I do apologise.
No, not at all. Happy for you to crack on.
Alison, your favourite topic, second staircases, and just begin by saying none of this makes any sense, does it?
Well, it sort of makes some sense. Yes, it is one of my favourite topics, and hopefully it was slightly light relief from the rest of building safety, just because it's easier, I think, to picture. In London, since February 2023, if you were going to build what's known as a residential building, whatever that might be, I think we all have a pretty good idea what we're talking about there. If it's over 30 metres in height, you need to have a second staircase. Elsewhere in England, there was, and still is, no requirement on a second staircase. The government indicated that they would be providing us with information with regard to this. It came out on Good Friday, and as from the 30th September 2026, everywhere in England where you're building a residential building over 18 metres in height is going to require a second staircase. There are transitional provisions, but to be frank, I think we've had enough warning that it would be prudent for anyone developing a residential building over 18 metres in height to now be designing such buildings with a second staircase.
Okay, what about existing buildings then?
Well, that's a very good question, Stuart. It's not at all clear. The government has indicated that there's no issue with safety with existing buildings that don't have a second staircase, which sort of begs the question, why are they introducing legislation to require a second staircase in new builds? I think it's a case of suck it and see. We'll have to see how commercially the world treats the idea that new builds over 18 metres require a second staircase, but existing blocks of flats don't. It will be interesting to see what happens.
Yeah, that's the bit that I think doesn't make any sense. Thanks very much.
So we're now moving on to the section of the Act, for the final part of discussion, section of the Building Safety Act that deals with allocating responsibility for the costs of remediating defects. And specifically, this is remediation contribution orders and building liability orders. We're going to talk about each one of those in turn, and in each case, I'll give a brief reminder about what it is that we're talking about, and Alison is going to talk us through a recent case relating to an RCO and a BLO to give us some insight on the developing jurisprudence. So remediation contribution orders first. Well, an RCO is an order that those associated with a landlord or a landlord as at Valentine's Day 2022 or a developer, so party associated with any of those, pays towards the cost of works that are required to rectify cladding or building safety risks, which arose in the period between 28th June 1992 and 2002, which are in a self-contained building or a self-contained part of a building, which has at least 2 dwellings and which is at least 11 metres or 5 stories high. You'll note there that we're talking about dwellings in this context, not residential units, and we've got a lower height threshold, 11 metres or 5 stories rather than your 18 metres or 7 stories. So it's a different threshold here, and an RCO can only be ordered by the first tier tribunal where it's considered just and equitable to make the order. And Alison is going to help us understand a little bit more about what just and equitable means as part of the discussion of a recent case.
Yes, thanks, Dom. First thing to say is that associated for an RCO is defined at section 121 of the Building Safety Act. And I'm mentioning that because associated means different things in different parts of the Act. But broadly speaking, for the purposes of today, you're associated if you're the parent company or sister company of the landlords concerned or the developer. So we're talking about that sort of situation. So piercing the corporate rail, which for us lawyers is a big thing. Yes, we've had a first tier tribunal decision, Triathlon versus Stratford Village Development Partnerships and others. Others include Get Living, which I'll mention in a bit more detail. This case, this first tier tribunal decision is extremely important and quite lengthy. So if you're interested, have a look at the blog referred to or the longer article that's referred to on the slides. Among other things, it looked at what just and equitable was, and I'm not going to go into all the points that it dealt with because there's not time here, but Get Living owned Stratford Village Development Partnership, who had developed the site, which was actually the Olympic site in East London, but they didn't own it at the time of the works. Triathlon was the long leaseholder, and they sought a building liability, a remediation contribution order against Get Living, and the first tier tribunal decided that Get Living should be the subject of a remediation contribution order, despite the fact they didn't own Stratford Village Development Partnership at the time that the development was actually developed out. There were a lot of other points they made about what was just and equitable, all of which went against to Get Living and Stratford Village Development Partnership. Just and equitable is going to be a very high hurdle to get over. A couple of other points that they made, which are worth bearing in mind, that a remediation contribution order can relate to costs that were incurred before this part of the Act came into force. This came into force in June 2022. So if costs were incurred, say, in, for argument's sake, June 2019, those costs can be form part of the remediation contribution order against someone who was not involved in the original contractual relationship between the parties, but it is associated with, say, a developer or landlord. And the other important thing to note is that a remediation contribution order can also relate to costs incurred in preventing risks or reducing the severity of building safety incidents. The best example we can give of this is, I think, wake-in watches. For those of you not familiar with that term, following the Grenfell tragedy, there were a number of buildings that introduced 24/7 security to basically knock up the residents should there be a fire in the middle of the night and get them out quickly. That was known as wake-in watch. Those costs were substantial and are substantial and can be recovered under remediation contribution orders as well, according to the Triathlon decision. So really wide-ranging and piercing the corporate rail quite considerably. It's going to be, it indicates it's going to be quite hard work to show that it's not just and equitable to make such an order.
Yeah, thank you, Alison. And now building liability orders, which again are a mechanism that appears in the corporate veil. And here, what we are talking about is liability that arises under the Defective Premises Act. So, for delivering a dwelling that is not fit for habitation, or again a building safety risk. So, as previously, that's a risk to people in or about the building that arises from the risk of spread of fire, structural failure. And it's worth noting that whilst previously we were talking about a height and a use requirement, that does not apply to the building safety risk element. So Defective Premises Act, you have to be talking about dwellings, but building safety risk can be any building of any height. And the effect of the building liability order is to make a specified body corporate liable if, at the relevant time, it was associated with the body corporate who is liable. And that's the route for piercing the corporate veil in this case. And as with an RCO, the order can only be given if the court considers it's just and equitable to do so. So we have a recent piece of case law, which I think was an extempore judgment, Alison.
That's right. Yes, it was verbal judgment. We haven't got anything in writing, so our information comes from the barristers and the solicitors involved in the case. I would just say, before I go on to talk about it a little bit, that associated here means something ever so slightly different. So if you're interested, you need to look at section 131 rather than 121 for remediation contribution orders, for what associated means for a building liability order. But for today's purposes, again, parent companies, sister companies, they're all going to be caught under the umbrella of associated. The Wilmot-Dixon Platter case involves the contractor Wilmot-Dixon pursuing a number of its consultants. It relates to a project, I think, in Woolwich in London, where Wilmot-Dixon have settled with the freehold owner and are now pursuing their consultants, including ACOM. And what ACOM did in these proceedings was to try and seek a building liability order against one of the other defendants, or one or more of the other defendants. And one of the issues that arose was whether, in fact, a defendant can seek a building liability order against another defendant, or whether it's only available to a claimant. Perhaps unsurprisingly, the court gave that short shrift. One defendant can seek a building liability order against another defendant. And what the court also said was that they will not allow the application for the building liability order to be hived off until the main claim is dealt with. They will deal with it all together. They are concerned that these cases should not drag on and on and on. They will group it all together and hear it all together. So that was an interesting and robust decision. There were also a couple of other points.
Liability is a prerequisite to a building liability.
Yes.
You have to identify the party who is liable and then show that the party subject to the order is associated with the party who is liable.
That's right. Yes, you have to show liability
sequentially. You don't have to first go against the person who is liable and wait until they fail to pay before you can go forward.
Yes, that's right. That's the second point that was made in this judgment. You don't have to go against the person primarily liable, and you don't have to wait for them to fail to pay you before you go for a building liability order against an associated organisation. And again, perhaps unsurprisingly, it's not necessary for you to show as well, when seeking a building liability order, that the party initially liable has disposed of its assets fraudulently. They can have done it entirely innocently. There can have been a restructuring of the organisation for entirely different reasons, but that does not stop you being entitled to seek a building liability order. So I think, like remediation contribution orders, we're getting a taste of exactly how wide they are, and the answer is they're very wide.
Yeah, and that commentary around what is just and equitable, I think, is really relevant and illuminating, for instance, in the context of corporate transactions,
Very much so.
where there's an acquisition involving a company who may have been associated with somebody with liability. And there was a thought, a hope maybe, that the just and equitable test would mean that if you're an innocent party to a transaction, you weren't involved in the wrongdoing, or they're not responsible for the defect, then it would be just and equitable to oppose a BLO. It sounds to me as though these two cases suggest that just and equitable, as you've said, is a much more difficult test to rely on from that perspective.
Very much so. And in respect of the remediation contribution order case, the point was made, this is not about who is liable, it's about who is to be held responsible for dealing with the building defects in buildings. Those with the deepest pockets seems to be the answer.
Thanks very much both for that. The next slide on the screen is something for which we must thank Iain. It's a flow chart that tries to tie together some of the points that we've discussed. It will be in the slides when they're circulated to you, and hopefully you'll find it of interest. Now, there have been some questions. There have actually been lots and lots and lots of questions. 17, I think, from looking.
That doesn't count the 13 that have been answered.
I've been busy typing away, Stuart, but I wondered whether the question that we might ask ourselves, and I don't mind kicking off if that's helpful, there's been quite a few around principal designer. So if I kick off a quick principal designer discussion, Stuart, and you have a look and pluck out the second one, because hopefully we'll have time to tackle a couple. And quite a lot of the questions that have been coming in while I haven't been speaking have been around that role. And for example, the questions include things like, can you subcontract that role? What if the contractor's not been appointed PD, but then is doing some value engineering? I think there's a whole lot of detail here to unpack, some of which, if we cast our mind back to the introduction of the CDM, for those of you who, like me, were involved either in the first time around or the second, is to do with, is similar in a sense to just that sense of ownership of the design process for reasons of safety, or for reasons of building regulations compliance. The duty holders owe statutory duties. The person appointed as principal designer, the person appointed as principal contractor, and the person who is the client, as well as contractors and designers, have statutory duties. Those statutory duties aren't easy to sort of draft or negotiate one's way out of. If you are the principal designer and you are fulfilling that function, you either continue to fulfill that function, or you perhaps formally have to say, I can no longer fulfill that function. If you are fulfilling that function, it is your statutory duty to look at the design, to see that in the role of the principal designer, if the design is built during the construction phase, then to the best of your ability, it will comply with the building regulations. So the really good but tricky questions that have been coming in while we've been speaking around that sort of delegation or that what if type scenario, perhaps you need to go back to the principle of these are statutory obligations, they bite, and it's difficult to sort of draft or negotiate your way out of them. Alison, Dom, any thoughts on that? Is that a helpful little summary?
Very helpful, I think. The other thing that occurs to me is if you change principal designer during the course of your project, maybe you've got a client side PD that changes, then the incoming principal designer has an obligation to do its diligence and be able to give the confirmations that are required in order to discharge that statutory role.
Thanks all. I'm conscious of time, Alison. Sorry, I've seen you've answered online one of the questions I was going to suggest we discuss, which is about second staircases. I'm conscious we've only got 5 minutes left. For any question we haven't answered, we will answer them. But there's quite a lot of discussion, pardon me, online about the principal designer and under the regulations. And to be perhaps slightly controversial, the Mills and Reeve view is that a principal designer for the purposes of building regulations does have to be a designer and will therefore have to carry professional indemnity insurance in relation to design. We quite often get into discussions when appointing a principal designer under the CDM regulations as to whether or not that is a design function, and lots of people who act as principal designers under the CDM regulations do not carry PI insurance for design. And I'm not going to dive into that debate now, but what I think we probably end this bit of the presentation by saying we are all certain that if you are going to be principal designer for the purposes of the building regulations, you are a designer and you will need PI insurance for design. The way the regulations are drafted, we don't see any way out of that. We've got 3 minutes left. So the next thing is to, as Iain gave it a heads up, the ink isn't yet dry on the JCT Design and Build 2024 contract, but we're having a webinar on the 21st of May to discuss that. So do please sign up for that. Do please give us feedback and any suggestions for topics that you'd like us to discuss. You'll get an email asking for feedback at the end of the webinar. And lastly, it leaves me to thank everyone for. We had over 300 people viewing it, so thank you everyone who's taken the time out of your busy days to attend the webinar. And I'd particularly like to thank Alison, Iain, and Dom, because the observant ones amongst you have noticed they did all the heavy lifting, and I just got to ask some questions that were written on slides. But the serious point here is building safety is incredibly complicated, and Alison, Iain, Dom, Lauren, who Dom referred to in the talk, and others members of the team are real specialists on it. It is complicated. Do please take advice. Thanks very much, everyone, and enjoy the rest of your days.